Hello all. In the previous video, we saw about the making of Indian Constitution. We also came to know that there were strong critics on the then Constitutional Assembly. Even the Constitution itself has underwent a lot of critics, and it was also called as a borrowed constitution. Yet, Indian Constitution is unique. How? We're gonna see that in this video. Without much ado, let's dive in. The Indian Constitution is dynamic and it's always on updation, as there has been a substantial change on several amendments, parts, and also there have been scenarios where the basic structure of the Constitution is itself altered. Let's see those features that makes our Constitution unique. The Constitution of India is the lengthiest of all written constitution of the world, just like the American Constitution. Our Constitution is very comprehensive, elaborate, and detailed document. In 1949, it contained a preamble, 395 articles, which were divided into 22 parts and 8 schedules. Presently, we have a preamble, 25 parts, which has 448 articles, 12 schedules, 5 appendices, and 101 amendments. And the 101 amendment talks about the GST. No other constitution in the world has this number of articles and schedules. This tremendous size is attributed to 4 factors: the vastness of the country and its diversity, influence of Government of India Act of 1935, which was already bulky, single constitution for both center and the state except Jammu and Kashmir, as it owns a separate constitution by virtue of Article 370 of the Constitution of India. Dominance of legal luminaries. Apart from these 4 major factors, it also holds the fundamental principles and administrative provisions, matters of ordinary legislations and political conventions. From the words of Dr. B.R. Ambedkar, the Constitution of India has been framed after ransacking all the known constitutions of the world. The structural part is derived from the Government of India Act of 1935 to a larger extent. The fundamental rights and directive principles of the state policy are from American and Irish Constitution. The political part is from the British Constitution. Other provisions have been drawn from Canada, Australia, Germany, USSR, France, South Africa, and Japan. Though the Constitution was derived from the others, the framers has taken care in making necessary changes and modification to suit the Indian regime, at the same time avoiding their faults. So, criticizing it as a borrowed constitution or a patchwork is unfair and illogical. Most constitutions in the world either function as a rigid or flexible, but the Indian Constitution is a blend of both. Let's see what means by rigid and flexible. A rigid constitution requires a special procedure to form, alter, or remove an amendment. This is seen in the case of American Constitution. A flexible constitution does not require any special procedure. Just like an ordinary law, it can be formed, altered, or removed. And this is seen in the British Constitution. That's why they can't write it down. In contrast, Indian Constitution is neither rigid nor flexible, but a combination of both. Let's put it in a simple way. Article 368 provides 2 types of amendments. Some provision can only be amended by a special majority of the Parliament, that is, 2/3 of majority is required to amend any kind of a provision. In some provisions, the ratification by half the total states is enough. For example, the GST bill. The Indian Constitution is federal in form but unitary in spirit. Let's see about the Federalism Feature. It is a two-government. It talks about the division of powers. It is a written constitution. The constitution upholds the supremacy, the rigidity of the constitution. It talks about the independent judiciary, and it also talks about bicameralism. Its unitary features are a strong center, a single constitution, a single citizenship, a flexibility of the constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions. It's to be noted that though the constitution holds federalism features, it was not mentioned anywhere in the whole constitution. The constitution opted for the British parliamentary system, which is well known by the term Westminster model of government. The principle of this model is the cooperation and coordination between the legislative and executive organs. There is another model which is followed in American Constitution called the presidential system of government, which we can see in another video. The parliamentary system is established both in center and the state. The features of Indian parliamentary system are presence of nominal and real executives, majority party rule, collective responsibility of the executive to the legislature, membership of the ministers in the legislatures, leadership of the prime minister or chief minister, dissolution of the lower house. There are some features that differentiate Indian system from the British. Indian Parliament is not a sovereign body. Indian state has an elected head, whereas in British it is a hereditary head. It is to be noted that the role of Prime Minister is so significant and crucial in both the system. That is why it is called Prime Ministerial government. The framers of the Indian Constitution made a proper synthesis between the British principle of parliamentary sovereign and the American principle of judicial supremacy. That is, the Supreme Court can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent powers. The judicial system is integrated as well as independent. Let's see how it's integrated. The Supreme Court stands at the top of the judicial system in the country. Below it, there are high courts at the state level, followed by subordinate courts, that is, the district and the other lower courts. This judicial system enforces the law both in central and state, whereas in American Constitution, federal laws are followed in federal judiciary and state laws in state judiciary. As an independent system, the Supreme Court is the highest court of appeal and the guarantor of the fundamental rights of every citizen. Hence, the Constitution ensured its independency through multiple provisions: security of the tenure of judges, prohibition on discussion on the conduct of judges in the legislature, fixed service condition for the judges, ban on practice after retirement, separation of the judiciary from the executive. Constitution provides a guaranteed 6 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, culture and educational rights, rights to constitutional remedies. A citizen can directly go to the Supreme Court for restoration of his rights. This gives an idea of political democracy. However, it is not fully applicable. It's subject to reasonable restriction. They are sacrosanct and can be removed or nullified by the Parliament through a Constitutional Amendment Act. It is to be noted that all the fundamental rights are suspended during national emergency. One of the novel features of the Constitution is its Directive Principle. They are enumerated in Part 4 of the Constitution and can be classified into three broad categories: socialistic, Gandhian, and liberal intellectual. This principle is meant for social and economic democracy. These are non-justiciable in nature, that is, the court can't enforce for their violation, as we saw in the fundamental rights. There were no traces of fundamental duties in the original constitution, which was framed in 1949. It was added during the operation of the internal emergency through the 42nd Constitutional Amendment Act of 1976 by the recommendation of Swaran Singh Committee. Later, in 2002, 86th Constitutional Amendment Act added one more duty, so now there are 11 fundamental duties, which is mentioned in the Article 51A under Part 4A of the Constitution. Some of the important duties are: respect the Constitution, respect the national flag and national anthem, protect the sovereign unity and integrity of the country, promote the spirit of common brotherhood amongst all the people, preserve rich heritage of our composite culture. Just like directive principles, the duties are also non-justiciable in nature. Constitution does not stand to any particular religion as the official religion of the country. This is supported by the provisions made in the Constitution. The term secular was added to the preamble by the 42nd Constitutional Amendment Act of 1976. It secures all citizens of India the liberty of belief, faith, and worship. It does not discriminate against any citizens on the ground of religion, which is explained in Article 15. Equal opportunity for all citizens in regard to public employment is explained in Article 16. Any section of the citizen shall have the right to conserve its distinct language, script, or culture, which is explained in Article 29. We can see more about this when we discuss about the secularism in India. But in case of Western concept of secularism, it connotes a complete separation between the religion and the state. The basis of Lok Sabha and state legislative assembly elections is the universal adult franchise. The voting age in the original constitution was 21, which was changed to 18 in 1989 by the 61st Constitutional Amendment Act of 1988. This added more value to democracy and enhances self-respect and prestige of the common people. There is only a single citizenship, that is, the Indian citizenship, even though the Constitution is federal in nature and envisages a dual polity, that is, center and the state. Whereas in countries like USA, each person is not only a citizen of their country but also to the respective state. Independent bodies like Election Commission, which ensures free and fair election to the Parliament, State Legislature, Office of President of India and Vice President of India. Comptroller and Auditor General of India, which audits the accounts of the centre and the state. Union Public Service Commission to conduct exams for recruitment to all India services and to advise President on disciplinary matters. State Public Service Commissions, same like UPSC but in state level. Here they provide guidance to the governor. The Constitution contains an elaborate emergency provisions to enable the President to meet any extraordinary situation effectively. The rationality behind these provisions is to safeguard the sovereignty, unity, integrity, and security of the country. There are three types of emergency: the national emergency, which are arised on the ground of war, external aggression, or armed rebellion, which is explained in Article 352. State emergencies on the ground of failure of constitutional machinery in the states, which is explained in Article 356, or failure to comply with the directive principle of the center, which is explained in Article 365. Financial emergencies on the ground of threat to financial stability or credit of India, which is explained in Article 360. During emergencies, all state comes under the total control of the center. So, we can say that the federal structure transforms to a unitary without a formal amendment in the constitution. This is a unique feature. There is no constitution in the world that supports three-tier government. Originally, the constitution was framed to have center and state, but by the 73rd and the 74th Amendment Act of 1992, a new tier has been included, that is the local, which includes panchayat and the municipality. With this, we come to the end of the unique features of our Indian Constitution. The next video is on the preamble of the Constitution. Click the like button if you have understood the concept and share it. Subscribe to our channel to get instant notification of the videos we roll. If you have any questions, please fill out the SYQ form. The link is in the description. Thank you.